Okay, Tom, the Constitution and family. Talk to me about Article 41.
Well, I always think at Article 41, the opening line is the most dramatic line in the Irish Constitution. The first half of that line is pretty standard. It says the state recognises the family as a natural, primary and fundamental unit group in society, which you might argue is just recognising a social fact, which is as true today as it was in the 1930s, albeit that we understand the family very differently now. It's the second part of that opening line that to me is very striking. It talks about the family being a moral institution possessing inalienable rights, antecedent and superior to all positive law. That's very dramatic language. Inalienable rights are rights that cannot be alienated. They cannot be taken away. Antecedent and superior. Antecedent means coming prior to. The family as an institution comes prior to the state and is superior to the state. The suggestion is that it's beyond the control of the state.
So, we're talking strong, authoritative, dramatic language. Has that then made its mark in the courts?
Yes, it has actually. Now, what I would say is it hasn't been taken literally. If that language was taken literally, laws prohibiting violence in the home, for example, would be potentially unconstitutional, and there's no question but that such laws are not unconstitutional. The courts have not taken it quite absolutely literally, but it has made its mark in the jurisprudence. Just to take an example, in the early 2000s, the HSE took a case against the parents of a young baby where those parents objected to the PKU test being carried out on their child, the heel prick test, and the parents won that case. The court found that the authority of the family was such, under Articles 41 and 42, that the state couldn't intervene regardless of the interests of the child in that particular case. Similarly, in the mid-90s, the Oireachtas tried to introduce legislation that would protect vulnerable spouses with respect to the ownership of homes, the Matrimonial Homes Bill, essentially which provided that automatically there would be a presumption that the marital home would be jointly owned on marriage. The court invalidated that legislation despite there being opt-outs in the legislation to allow couples to decide otherwise, because the court found the language in 41 was such that the decision-making authority of the family was, as it were, sacrosanct. Now, the decision-making authority of the family, of course, again, it is important, but very often, or sometimes, it translates into decision-making authority of a powerful figure within the family to the cost of vulnerable members, whether that might be wives or children.
We've had some constitutional change around the family and the marriage equality referendum, but the Constitution's still very, very firm. It's marital families.
It is. The marriage referendum was hugely significant in 2015, and indeed it amended Article 41, but really just in kind of a technical way. It just meant that marriage was open to homosexuals on the same basis as heterosexuals. But you're right, Article 41, the case law is absolutely clear on this. The court made decisions on this as recently as 2018 in M and the Minister for Justice. The family in the Irish Constitution is the family based on marriage, and non-marital families don't enjoy any protection under Article 41 of the Constitution.
The citizens have a lot to examine in these articles in the Constitution, and not just what the Convention looked at and that women in the home clause, which has been referred on to the citizens here as well.
Yes, Pádraig, the woman in the home provision, of course, is in Article 41 later than the provision I talked about earlier. The Convention reached a pretty emphatic conclusion about the woman in the home provision. It is, I think it's fair to say, a sexist clause, really out of time. What's striking for me, though, or interesting for me really about that clause is that it's not actually out of sync with the rest of Article 41. In fact, it chimes with the overall ethos of Article 41. It's overstated the extent to which Catholic social thought influenced the Irish Constitution generally. It had no influence, or almost no influence, on much or most of the Constitution, but on Article 41, 42 and 43, that is family, education and private property, that's where Catholic social thought made its mark. So people might think that that's problematic in 2020 and beyond. That's for the citizens.